Independent state legislature theory gained traction in conservative circles since the Supreme Court case of Bush v. Gore, and would again resurface in the aftermath of the 2020 presidential election and then President Donald Trump's efforts to overturn the results of the election. His legal team argued before the Supreme Court that under that independent state legislature theory, that state legislatures could select electors who would cast their vote for Donald Trump, despite the fact that the certified electors had cast their votes for the candidate who won the popular vote in their state. The court refused to hear that argument. Look, I don't trust some of these highly partisan state legislatures at all. Some have made clear that they're willing to do anything to have their candidate win, even if it thwarts the will of the people. And while the court may issue an opinion that could give them a lot more autonomy, I also didn't hear anything in today's arguments that suggests that the court is prepared to let them overturn any election. Joining us now is Matthew Seligman, attorney and fellow at the Constitutional Law Center at Stanford Law School. He recently wrote an opinion piece for Politico magazine that is entitled "How Panic on the Left Could Spark a Constitutional Crisis." Thanks very much for coming on the show. Appreciate it. First of all, let me just ask you big picture. You listened to the arguments today. What do you think that the court is likely to do here?
Thanks for having me on. I think the court's likely to seek a middle ground. There didn't seem to be a lot of appetite for the maximal position that the North Carolina state legislature was pushing. That maximal position that the state legislature is completely unconstrained by the state constitution, it seemed like only Justice Gorsuch and maybe Justice Alito and Thomas might be interested in that. So it seemed like the center of the court was looking for something more moderate. Now, what that moderate position ends up being, we'll have to wait and see in June when the court renders its decision.
But even if the court were to take what is viewed as the most radical position, you've made it clear that that doesn't mean that suddenly they can be overturning elections in these states, right?
That's absolutely correct. Under no circumstances, no matter what position the Supreme Court adopted, including the most maximal version of the theory, under no circumstances would state legislatures be authorized to ignore the results of a presidential election and appoint their own electors after Election Day. The reason is because Article 2 of the Constitution gives states, and if you buy the theory, state legislatures, authority to determine the manner of appointing electors. But it also says that Congress gets to decide the time for choosing electors, and Congress has said Election Day. So no matter how much authority, unconstrained even authority, that state legislatures have to decide how those electors are appointed, they have to be done and chosen on Election Day.
Sorry, please, go ahead.
And what that means is that the theory that was advocated by Trump and his allies after the 2020 election was always wrong. State legislatures could never step in before or after January 6th to appoint their own electors.
And that's a critical point, because that is something that Trump and his allies tried to pursue, and it is something that people are linking to this argument, right? To suggest that, oh, if the court sides with North Carolina, with the legislature on this, that'll mean the next time around, if they try the mischief, which, by the way, I think, some states may, and that's dangerous, that the argument goes, oh, well, then they'll be able to do it. But that's not true.
That's right. It's just incorrect, no matter what the Supreme Court decides and more. And I agree with you. I think it is dangerous, and I can't say that state legislatures aren't going to try this. They almost tried it in 2020, and as partisanship continues to peak, as extremism continues to peak, especially in state legislatures, there's a risk that a state legislature may try in 2024 where none did in 2020. But that doesn't mean it would be constitutional to do it, and it doesn't mean the Supreme Court wouldn't step in to stop it.
Right, and even though you're giving us very sober analysis, to which people on the left may be saying, oh, he's just a right-wing ideologue, et cetera, you also think that you wish the court wouldn't even take up this case, right, is your position?
Yeah, that's absolutely correct. I've been concerned about the problem of election subversion for years, and I think it's a serious, serious issue. I also think that this case, if the Supreme Court adopted the maximalist position, which again, it seems like it won't do, but if it did, that could do serious damage to democracy, particularly with respect to partisan gerrymandering. The Supreme Court has previously held a couple of years ago that the federal constitution doesn't provide any limitations on that. Yep. So all we have left are state constitutions.
Thank you for watching. Go to newsnationnow.com to find NewsNation on your cable provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.